You're copying somebody's copyrighted material. What has your action done to harm the owner of the copyright of the value that they otherwise might have obtained from their copyrighted work? Maybe what you're doing is copyright infringement that will not be considered fair use.
Welcome to the BJU Press Teacher Edition podcast, where Christian educators are encouraged and inspired as we bring you interviews, practical ideas, strategies, and answer your questions about teaching in today's culture. And here's your host, Jenny Copeland.
We often hear the saying, educators are excellent borrowers. I mean, we know how to find deals. We can repurpose items that others see as junk. We buy really odd things at yard sales, and we love dollar stores. Educators are often very proficient at finding what they need and recreating it, resizing it, recoloring it, remaking it, you name it. But how often do we stop to think about who really owns those items and where they really came from? In frugality, either knowingly or unknowingly, educators can often cross the line when it comes to copyright. If you were to visit a school and look around, you might see wall decor, maybe some that was redrawn from a cartoon or a superhero figurine or something from a coloring book or maybe from a sticker that's now larger than life on their wall. What about those sports logos printed from the internet? There's comics at the bottom of tests. There are song lyrics up on a screen in chapel or popular youth videos even playing while students just enjoy popcorn and a reward for their good behavior. These all look really harmless, fun, they're engaging, and they are, that's true. But as we say, the end does not justify the means. Copyright law in schools is often overlooked. Today, we're going to shed some light on that topic, and in a very practical way. We're going to look at specifics and how we can carefully do what is right in this area. Listeners, I am so glad you're back. Welcome. I love talking all things education, and I'm so privileged to serve as the host of this podcast. I'm privileged to talk with incredible experts each week on this show, and I'm so honored that you would take some time to join in and listen. I don't take your time for granted. And as I prepare for the topics, my heart is that I really want to find those topics that are most practical, most helpful, and uplifting for the time that you share with us. I do have one ask of you, though, as listeners. Would you help us share this show out with others? Teachers know teachers. We are a connected group for sure. Would you share this show out with teachers at your school, outside your school, retired educators, rising educators, wherever they fall in the educator spectrum? Would you share this with them? You just never know how it might be a help and a blessing to them. Feel free to share our website with them. That's teachereditionpodcast.com. A lot of great information there about the show, about our guests, and of course, each episode. There's also a place for you to leave your questions and even your suggestions for upcoming episodes. I would love to have a whole stash of questions to share and topics to dive into as we sail into year 3 of the Teacher Edition podcast. You can also share out this show on social media. We are Teacher Edition Podcast on Facebook. You can find us on Instagram and TikTok at Teacher Edition Pod. And then, of course, don't miss us on YouTube where you can watch these interviews. We can be found there as Teacher Edition Podcast. Okay, so as I mentioned, we're going to talk copyright in schools today. This is a topic that applies to everyone in the school. It isn't just the administrator's responsibility or the office personnel to keep track of that. And contrary to some thought that's out there, not everything is free reign for teachers. I know, bummer, right? Copyright is an interesting element in that it isn't open and blatant. It isn't, I guess it's something more hidden. We can snip pictures from the internet, copy lyrics to a song. We can recreate cartoon characters by blowing them up with opaque projectors, and on and on. You can just do that so easily and without much notice by anyone. Now, we wouldn't go into a store and steal a poster, but copyright really has true ownership and appropriate use as its core. Just like we would not steal in a brick and mortar store, we should have that same knowledge, awareness, and integrity to not steal in those areas that aren't so open and obvious, like copyright. For a number of years, I worked in the offices of the leadership in an organization, and one of my responsibilities there was to oversee copyright in a number of different areas. It was really eye-opening, and it really gave me an awareness of the abuses of copyright. It also gave me an increased burden to bring awareness to educators so they could do what's right. Not because someone was watching or because they might get caught, but because it was right, whether or not anyone knew. So let's unpack copyright for schools in a really practical way today. So joining me, I have Jim Bagarazzi, a lawyer who deals mainly with copyright, registration, things along those lines. Jim has an undergraduate degree in physics, and he earned his law degree from George Washington University Law School. He has been admitted to the bars of South Carolina, the U.S. Patent and Trademark Office, the U.S. Court of Appeals for the Federal Circuit, the U.S. Court of Appeals for the Fourth Circuit, the U.S. Claims Court, and the U.S. Supreme Court. He's a member of the Carolina Patent, Trademark, and Copyright Law Association. And actually, he served previously as the association president. He's also a published author. So I've had an opportunity to interact with Jim on several occasions for various projects and products. And I just greatly appreciate his knowledge and expertise. He's very patient and he's very willing to explain things in terms that I can understand. And he just is really helpful in helping us to choose the best course for what we're trying to accomplish. Jim, it is such an honor to have you here with us. Thanks for being willing to give up some of your time to be on the show today.
It's my pleasure, Jenny.
Okay, so as we get started, a copyright lawyer might be new to some people. So I wondered if you could tell us a little bit more about what do you do? What does it mean to be a copyright lawyer?
Well, basically, it means that you are an attorney admitted to practice before one of the states, including the District of Columbia, where I used to be admitted to practice before I gave up that license. And your area of expertise is sort of narrowed to the law of copyright, which in the United States, anyway, is law that is defined by a federal statute. So the reason that the statute exists is because in the U.S. Constitution, there is a provision, Article 1, Section 8, Clause 8, that provides for copyright protection. And so the Congress implemented that right or that legal authority by enacting the various copyright statutes over the years. I think the first one was like in 1792. The most recent large revision of the copyright statute was in 1978. And there have been some since then that have addressed particular issues like, for example, the Digital Millennial Copyright Act, which we'll probably talk about a little bit later on.
We should. Interesting. Okay, so we clarified you're not copyright police. So you're not running around trying to find infringements. You're trying to help people follow the law. Does that make sense?
Right. As an attorney, basically what I do is help people resolve legal conflicts that arise under the law, in this particular instance, copyright law. But beyond that, clients come to me to want to know what their rights are so they don't run afoul of the copyright statutes and get into trouble.
Yeah.
Very often the clients that come to me are already in trouble because they've infringed the copyrights and the copyright owner have found out about it and think they've been damaged in some way and are demanding compensation. That's not uncommon for the ways that I undertake representation of clients, and other attorneys in my firm do the same.
Interesting. Wow. Sounds like your days have a lot of variety. Okay, so there are terms that float around in education when it comes to copyright. So I wondered if maybe we could start with talking about some of those and specifically how they apply to educators. So one that most people have probably heard of is public domain, and whether or not they've heard of it, they may not totally know what that means. So I wondered if we could look at that one first. What does it mean? And then secondarily, how does that apply to educators?
Yeah, well, public domain basically describes the status of copyrights that may have existed at one time or are in a certain category. So, for example, when a copyright is granted, it has a particular term of enforceability. But when that term expires, then the copyright that was protected passes into the public domain. It is then free for anyone to what would previously be violations of the rights that are afforded to a copyright, they no longer can be enforced. So you can copy it, you can reproduce it, you can prepare derivative works, etc., of that copyrighted work. There are certain forms of expression which the copyright statute says are not protectable by copyright. For example, short words and phrases, ideas. You may have heard the expression that only forms of expression of an idea are protectable by copyright. The idea itself is not protectable by copyright. So ideas are in the public domain in that sense. People's names, blank forms, these are examples of, while they are forms of expression, the copyright statute says we're not going to allow copyright protection for those kinds of things.
Interesting.
So essentially, in that sense, those also are in the public domain.
Mm-hmm. Wow. Interesting. Okay, so another term that is thrown around a lot in education is fair use. So I've had a number of educators tell me they can use something because it falls under fair use. So I wondered if we could tackle that one a little bit. Jim, could you clarify what does fair use actually mean? And then again, bring that specifically down into educator world, how it applies.
Okay, so fair use is defined in the copyright statute. And essentially, if you infringe a copyrighted work. And when I say infringe a copyrighted work, the copyright statute says upon the granting of a copyright in a particular work, whatever that work may be, it might be a story, a play, a song, a photograph, a motion picture, etc. Whenever you are granted a copyright in a work, you are granted a bundle of rights with respect to that work that you are entitled to enforce if somebody were to commit an action that was within those bundle of rights. Okay. The one that everybody knows about, obviously, is copy it. You can't copy a copyrighted work. There are a number of rights, and these rights are all delineated in Section 101 of 17 U.S. Code. 17 U.S. Code, Title 17 of the United States Code, that's where all of these copyright laws are listed. And like any law, there are gaps within the language of the law, which is why we have the Supreme Court. So the courts determine, okay, well, what does this mean in relation to this particular set of facts? But in any event, getting back to the original question, so if you violate one of the rights that are owned by the copyright owner, you are a copyright infringer. Then the statute says, however, under certain circumstances, if you can prove these circumstances exist, you will not be deemed liable for the remedies that the statute permits to the owner of the copyright upon a violation of one of these rights. And that portion of the statute is called the fair use provisions, and it's come to be known as the fair use doctrine. And there is a specific listing of the types of things that a court would consider to determine whether this is a quote unquote fair use of the copyrighted material in this particular instance. So these determinations are, there's no easy button to push. These determinations are very fact specific. And so typically what happens if you violate a copyright, the owner of the copyright must ascertain that violation in a court of law. The owner of the copyright must bring a lawsuit in federal court. Only federal courts have jurisdiction over copyright cases.
Oh, interesting.
And they must allege a violation of one of the rights of copyright, and then the alleged infringer would have to prove that they didn't do it for some reason. In other words, one of the specific allegations that must be made in order to prove a claim of copyright infringement was missing. Or if all of them are present, then one of the potential defenses available to the defendant is, yes, I did what would ordinarily be an infringement of the copyright. However, those acts should be deemed to fall under the fair use doctrine of the statute, and therefore there's no remedy that can be obtained against me. And there are four delineated factors that are considered by the court when these situations arise. And I'm looking at them. I have a little cheat sheet here.
That's okay.
There's two that are probably more important than the other two. One of the most important ones that a court will look at when one of these lawsuits is filed and the defense of fair use is raised is what did the action of the alleged infringer, what effect on the copyright owner's use of its own work would that have? In other words, did it deprive the copyright owner of something significant that otherwise the copyright owner would be able to do? For example, if you are a songwriter and somebody records your song and is making a lot of money off of it and is not paying you, that might be a very substantial thing that would not be deemed a fair use.
Yeah, makes sense.
Typically, if the use that is made or the violation of the right of the copyright owner is something that has significant commercial value that is now deprived from the owner of the copyright, it's very unlikely that that will be deemed a fair use.
Right.
So that's one of the more important
Okay.
of the factors.
Okay.
Another related factor that maybe is secondarily most important is what was the violation of the right? What right was violated of the copyright rights that are accorded to the owner? And so what is the purpose and the character of the use that is being made by the alleged infringer? Is it commercial? If it's commercial, the likelihood that you would be deemed to be entitled to the fair use defense is pretty low. One of the other factors is the nature of the copyrighted work. Is it something that is of limited commercial value, and you have now taken that commercial value from the owner of the copyright by virtue of what the nature of the copyright work is? Then that is unlikely to be deemed a fair use. And then how much of the copyrighted work has been used relative to the work as a whole? If it's just snippets here and there, that's one thing. But if you're quoting large swaths of whatever the copyrighted work is, if you're taking a movie and showing a lot of it in a commercial way, obviously that's not likely to be deemed a fair use. And even if you're doing commentary and you're showing parts of the movie that are the reason that people are likely to go see it because they want to know what happens, and then you're showing it on TV, that's a problem, probably. I don't know of a specific instance of that, but, based upon my thinking anyway,
Absolutely.
that's going to be a problem.
Definitely makes sense.
So that is something that is very much in the, I would say, the ordinary person thinks that they know what a fair use is. And I think, to be fair, it's because the statute itself says it lists certain things which tend to be a purpose that might fall within fair use, but that's not the end of the story. And so one of them is teaching, okay? It specifically mentions teaching, and it mentions it and it puts in a parenthetical, including multiple copies for classroom use. So basically it almost invites teachers to copy things and think that it's fair use. Well, it might be, depending upon all of these other factors, but it's sort of a Trojan horse there, if you will, that it sort of suggests to teachers that, okay, because we're a teacher, we can pretty much do what we want. That's not the case.
Right.
And there are situations where, uh, what you might have thought was going to be a fair use because of the amount of copying that was done, because of the effect it had on the underlying work, because the copyright owner was not able to sell as many as they did before, uh, you're going to be in trouble if they
Right.
find out about it and they bring you to court. I guess from the standpoint of a teacher, you might want to be more familiar with the fair use provisions and ask yourself some of these questions. Okay, if I make this copy and if I do this with the copy, in other words, I try and make a copy and then I start giving them out to all my students, they don't have to buy the book. Is the publisher going to be happy about that? Not necessarily, especially if the publisher's been selling the book to your school, you know, and all of a
Exactly.
sudden the sales go down. You're
Right.
not buying anymore. That's something they might look into, and so you might want to think about that.
Right.
But there are some instances that are technically copyright infringements, and whether they would or would not be deemed entitled to the fair use defense, in the end, maybe the amount of liability in terms of what the remedy would be is not worth the cost of going to court and taking the court's time. Uh, and so the owner of the copyright will never bring a case. They might not even
Right.
hire a lawyer to send you a cease and desist letter or a demand for some kind of payment.
Right.
Um, a fair number of the cases that we get in my firm are cases where people have copied things off the internet, like an image of some sort. And there are photographers that that's how they make their money, by selling the photographs they make. And they there are organizations that make themselves available for a fee to photographers, and they will search the internet for the photographers' photographs that are being used without a license. And those organizations have attorneys on retainer that will send the infringer a letter and a demand for a couple $1,000s, $5,000, whatever it is. And so once they get one of those letters from an attorney, then they go looking for their own attorney to.
Of
And
course.
so we get a fair number of those.
Yeah.
As long as we're on the topic, I would just caution that. So the term of copyright is very long. And so if you're getting a photograph of something that's of recent vintage, chances are there's a copyright in it.
Correct.
And so make sure that you got permission from the owner of the copyright before you start making copies and distributing it on your website or whatever.
Yeah, for sure.
Because likely as not, that's somebody's copyrighted image. And if it's a photographer, you're liable to get one of these letters. And
Absolutely.
yeah.
So something I heard said quite a few times, a word that was used was might. That might count. It might not. And I think it's really imperative that we as educators take heed to that, because it is, like you said, it's up to the judge, when they look at it, to say, okay, whether, to decide whether or not that might fall within that. But this is where we can go above and beyond to say, above reproach in this, to stay well within the bounds of that. So I think that was one takeaway. That was a great explanation, because fair use is big. It's not just a golden ticket for everybody to do what they want. There are a lot of things to consider there. And then that word might is really, really important, because it might fall under fair use, it might not, and we need to make sure we are well within the bounds of that. So you started to talk a little bit about some scenarios, and in a minute, I really want to get into some specific scenarios that are really common in schools. But really quickly, before you do that, what would you say are some ways that copyright is commonly abused or overlooked in an educational setting? You kind of mentioned a couple of them, but are there any that really stick out to you?
I don't know about individual teachers so much, but so if you run a blog or something, if you're a teacher that runs a blog and you allow users of the blog to post things on your blog, you need to be careful about that, because if somebody posts an image or expression that infringes somebody's copyright, that person is liable for copyright infringement, but so are you, because you're now reproducing it and copying it and
Right.
making and distributing it on your blog.
You own the blog.
So that's a potential problem.
Yeah, for
And
sure.
if you're at a school and you have a website and you allow people to post on the website, and this arises sometimes in my practice because I represent some universities, and they have lots of professors and lots of students, and
Sure.
there are lots of ways where people unfamiliar with the rules of copyright will post things
Absolutely.
on their website without their knowledge until they get one of these cease and desist letters, and then I get a call. And so a private school or an individual needs to be aware that they need to protect themselves against that happening in some fashion. And the best way to do it is, I mentioned before, something called the Digital Millennial Copyright Act.
Right.
It was something that was passed in 1998, so 20 years after the main change. But it was done to protect the infant internet at the time, which is now burgeoned into a beast. But at the time, it needed protection, and so people that were making available to the public websites were given this protection under this act against the very thing I was just talking about. Somebody posting something on their website and it being an infringement of somebody's copyright and being liable to be sued in federal court for it.
Sure.
So the act provides a specific section for what's called safe harbor provisions. And basically, if the internet service provider, and what is an internet service provider? Well, an internet service provider is a pretty broad description, but if you operate a website, you're probably an internet service provider. If you operate a blog, you're probably an internet service provider. And so you would potentially qualify for this safe harbor provision. And basically, it requires you to register with the U.S. Copyright Office an agent that is authorized to receive complaints about copyright infringement on your website or on
Right.
your blog. And it provides a procedure by which you must deal with these complaints. And as long as you register and as long as you have these procedures available, and your blog and your website must make them known. In other words, I don't know if you ever go on one of these websites, go on Amazon, go on. There's like a legal section, okay?
Right.
That's where these things will be found, in the legal section. There may be even a legal section that there might be a link that says copyright on it too.
Right. Sure.
Sometimes it doesn't say that. It just varies. But in any event, that's why they have that there. They want the protection of the safe harbor provisions of the Digital Millennial Copyright Act.
Got it.
And once you do that, when you get one of these complaints, if you deal with it in accordance with the requirements of the act, you are shielded from liability. And one of the things you must do is you either must take the alleged copyrighted material from your website, take it down, or you must block the public from accessing it, one or the other. And as long as you do that within a reasonable time, and it's typically within a few days, you're not, you can't just leave it on there for weeks. But as long as you do that, then you won't be liable for the remedies for copyright infringement.
Interesting.
And so that's something that you might want to
that's great.
Keep in mind, especially if you're a private school or if you are an individual that operates a blog.
Yeah, for sure. Yeah, and I want to touch a little bit more on technology and how it's impacted copyright law. I want to jump really quickly. I want to be aware of time so we can hopefully move through these quickly, but I'd love to get your comments on some common scenarios that educators face in a school. So let's start with classroom decor. So teachers are creative, they're talented. They also like any opportunity to save money, even make something themselves if that would save I don't know about time, but definitely money. What should educators know about creating their own decorations? Like I'm thinking specifically when they're taking cartoons or maybe something like Disney characters or action figures and enlarging them, maybe from a coloring book or stickers, things like we all know, like Snoopy or Disney princesses or the Grinch, things that are really fun to put in your classroom, but they want to make their own and save money. What would you say?
Okay, think about what you just said. Save money. How are you saving money? You're copying somebody's copyrighted material. So there you go into the fair use issue of, okay, what has your action done to harm the owner of the copyright of the value that they otherwise might have obtained from their copyrighted work? So that should tell you right away that maybe what you're doing is copyright infringement that will not be considered fair use.
Well said. Okay, so what about comics? So I had several teachers coming through school would like to put comics at the bottom of the test, like they would photocopy them out of the newspaper or print them off from online or put them in their PowerPoints. I mean, they're really fun. What about that? Can they just be copied and put on quizzes, added to presentations, anything along those lines?
It's copyright infringement, and you'll notice on various comics there is a copyright notice. And if there's a copyright notice and you copy it, you will not be deemed a quote unquote innocent infringer. So that's a bad thing to be if you're an infringer.
Yes.
Again, what is the extent of the copying that was done? How much was it distributed? And there are licenses that can be obtained from
Right.
these instances, and the licenses may be very minimal in terms of the amount that you would be charged. And it typically depends on how extensive the use is going to be.
Sure.
And whether they have licensed this image before. In other words, certain comics are licensed, syndicated, and they earn fees. And if that's the case, and you start making copies, the likelihood of this being uncovered is probably very low. But once it is uncovered, it's a Pandora's box about, okay, then I'm going to start delving into it. How many years have you been doing this?
Right. And right is right. Regardless.
you can go back several years in terms of the amount of damages that you're entitled to collect before you file the suit.
Sure.
So,
yeah, good thoughts.
You just need to be aware that if what you're doing is saving money, why is it saving money? It's saving money because you're not paying the owner of the copyrighted work what they're entitled to.
Right.
And like you said at the beginning of the program, everybody likes to save money, but you don't want to be stealing in order to do that.
Absolutely. Right. Okay. So I'm guessing I can figure out what your answer is going to be, and it's going to be a big ditto mark to this. What about sports teams' logos? So I'm sitting here in Greenville, South Carolina. We're wedged between, USC, the Gamecocks. We have Clemson. Everybody loves the paw. It's on everything. It's on the roads. It's, people make their own. Okay. But what about that? I mean, they're on websites. You can copy from them. You could put them on your PowerPoints, your handouts, put them in your classroom decor to tell who you're supporting. What about logos?
Well, I need to be a little circumspect in the answer to this because I represent Clemson University. And so, I'm one of the attorneys that you're liable to get a letter
for your paw there.
Exactly. In general, copyrighted material is something that is, a work of art of some sort.
Right.
So a lot of these logos may be very creative and might be subject to some kind of copyright protection, but typically those instances are liable to be litigated on the basis that the logo is a recognizable trademark that has acquired goodwill over the years because people like the team that's associated with it, the Atlanta Braves or whatever.
Sure.
And because of that, it's a violation of the trademark rights as opposed to the copyright.
Right.
So the typical trouble you would be in would be trademark infringement as opposed to copyright infringement, but you'd still be in trouble.
Okay, so I'm not even going to touch on the thing of the famous right click and copy paste off the internet because I think we've definitely covered that thoroughly. So let's jump to song lyrics and music. So many teachers like to sing with their students and they want them to have a copy of the music. Or maybe they just want to put the words up on a PowerPoint or something, maybe for chapel, or copying music out of a book so everyone has their own copy. Thoughts on that?
Yeah, I mean, there are everything that you've just mentioned. It would violate a right that is afforded to the copyright owner in some respect. The copying, the display, uh, displaying to an audience is a distribution of some sort. And so the public performance of audiovisual works is an infringement of the copyright in those works. So all of those are infringements. Now, I will say that it's not uncommon for, especially if it's provided to a school. So some of these things are provided under a license.
Sure.
And even if they're not provided under a license when they are acquired by the school, you can acquire a separate site license from some of the licensing
Yes.
bodies. ASCAP, the American Society of Composers, and something or other, and then BMI,
Right.
Broadcast Music.
Like,
That's another one of those bodies.
mm-hmm.
They offer licenses depending upon the use that is intended and the work that is going to be licensed. And there are some songs that are in the public domain. And so if you want to do one of those activities, first thing to ask is, okay, is the song in the public domain? Like, for example, Happy Birthday, it's in the public domain. School plays,
Oh,
uh,
right. Yes.
school plays, those plays are copyrighted works and you do not have the right to perform them. Even if you can buy the script, but that doesn't necessarily give you the right to perform the work, because that's a separate right from the actual written text of the
Yes.
script.
Yes.
So that's something to keep in mind. And, sometimes when you acquire these plays and whatnot, some of these rights will be attendant to the acquisition. And you might want to make sure that's the case
Yeah.
when
Good
you do it.
advice.
And then if you have permission, you have written permission, then you don't have to worry about it. But if you don't, then you might have something to worry about, especially if you're going to start advertising this play and you're going to start charging
Sure.
admission for it. And you're going to have several performances of it. That's liable to get some traction, and somebody's liable to write you one of these nasty letters
Yeah.
if you do that. And then you'll have to look and see if, well, do we have permission? What's going on here?
Yeah. That's great.
So that's
Um,
something that happens a lot, I guess, in a school context.
Yeah, that's perfect. Exactly. And I'm glad you mentioned those different agencies that you can, pay for a school license through. And it does give you a little bit more opportunity to, put lyrics up on a screen or something. It's good to remember on those that, again, not all songs are covered. I have worked with some schools and they thought, well, I bought a CCLI license, so I guess I can put any screen I want or any music I want up on the screen. That's not true. You have to look to see if that song is covered by that license. So that was really
Exactly.
good.
That's a good point. Yeah.
And I'm glad to, early on, you mentioned, the example of textbooks. And again, those are copyrighted, just making copies if a student forgets their book or they lost it. And I'll just make copies for the rest of the year. Things like teachers pay teachers, very popular among teachers. And they buy those resources for themselves. And then, well, I have 4 or 5 other teacher friends. I'll just make you a copy too. Well, again, if you read what the license says, it says this is only for you to use, not to distribute. So I think that's all really great and kind of falls under what you just said. What about videos? So some teachers find it really easy to just, plug in their favorite cartoon or, feel good story from their house. They bring it and the students enjoy the entertainment. The teacher's getting some emails done or grading or whatever. Is it okay to have a public showing like that just because it's a school? You mentioned about plays. What about videos?
Well, typically every video that you buy, in the store is for your own personal use and limited performance. So in other words, if you're in your house and you invite the neighbors over, you can probably play that and not violate that
Sure.
provision. But if you bring it into school and start showing, 30 kids 3 times a day or 3 different classes, that video, that would not be within the normal purview of one of these purchase licenses that you get when you actually buy the video for your own personal consumption. So that's probably not okay.
Right.
Well,
Agreed.
and you have to show. So if you're showing it to 90 students, three classes of 30 students, you know, what would it cost for them to buy it themselves, or for their parents to buy it so they could see it, or rent it, or however they're going to consume it,
Sure.
or stream it from some streaming service. If there's a cost involved, then typically if you're circumventing the acquisition or the payment of that cost, an alarm bell should go off in your head. Okay,
Sure.
am I entitled to do this? Or what if I get caught doing this? Am I going to be able to say, okay, this is fine. This is a fair use? That, you need to start asking yourself these kind of questions.
Right. Okay, so we talked a little bit about technology, and I know we're running really close on time, so I hate to crunch this question, but I definitely want to get it in. Talk quickly about AI. I know this could be a whole podcast in and of itself, but what are some things that educators should be aware of when it comes to AI? Like, how can AI generated materials be used? Can I take copyrighted information like a book or maybe a children's story or whatever and feed it into AI for it to change it? And I know you've talked a little bit about this, so I'm guessing this is going to apply to AI as well.
Yeah. So currently, this is a hot topic in the legal field. And the Supreme Court has said some things about it, but it just touched the surface. And so recently, I think I may have mentioned to you that the United States Copyright Office has been preparing a report about, okay, what are the issues involved with generative AI programs? And, essentially those programs need to be trained on materials.
Right, right,
And, most of those materials are not in the public domain. And the question is whether the training of a generative AI program is a quote unquote transformative use that does not, for a different purpose than the purpose of the original copyrighted work. Okay. That is going to be litigated. That is going to be the subject of some private agreements between some of these companies that are wanting to do that and the companies that own the material that they want to feed into their, generative AI program. The Copyright Office issued this report earlier this month. And as soon as it was issued, the Trump administration fired the Register of Copyrights because they didn't like what was said in the report, ostensibly. And so the person that was fired is now suing the Trump administration because the firing was, unlawful. But be that as it may, they issued a bunch of resolutions or potential resolutions of some of the issues that are arising in this context. And, the question is whether that report is reliable because it was issued and then the person that issued it got fired. So it's kept it up in the air. And eventually, I think, probably private parties are going to bring lawsuits and the courts are going to weigh in on it. And maybe the Copyright Office will issue regulation. Generative AI program is going to take that copyrighted work and provide an output. Okay.
right,
If the output, to the extent that the output resembles large chunks of the copyrighted work, that may not be deemed a fair use of that activity. And so by the teacher feeding that into the generative AI chat box GPT, that is part and parcel of the action that
right,
ultimately is not going to be considered a fair use. And so
right.
you're stuck with that. And so until the law is somewhat clarified about whether those kinds of activities would be considered, a fair use, even if the the intention and the result is for some kind of educational purpose, how much of the work was used,
Correct.
what effect does it have on the owner of the copyright of the original work that you fed in? Those are going to be questions that are going to have to be answered in
Sure.
that particular instance. So,
Wow. Very insightful. That's great. And it sounds like we just need to be really careful. Just be careful. That word
yeah,
might
I mean,
is in there.
there's no easy answer to it now,
Right.
and you may need to look at it from the standpoint of the fair use analysis that you would undertake for anything that
Yeah.
you. So you've copied something, and you're allowing this program to copy it and do something with it, and provide an output, and all of those are issues that will determine whether what you have done is going to be
Right.
uh, safe under the fair use doctrine.
Yeah, that's great. Okay, in our final minute of the show, as we wrap up, what advice or maybe rule of thumb do you have for schools when it comes to copyright? I know this is a huge topic, and I'm sure that for some of our listeners listening in today, this feels overwhelming. This is huge. How do you keep all this straight? You do this every day. We don't. Like, how do you boil it down? Do you have 30 seconds of advice? What would you give them?
Okay, ask yourself the question, what am I doing? Am I copying? Am I distributing a copyrighted work like a video to an audience that would co-opt the ability of the owner of the copyright to obtain money from that because they would sell multiple copies? Ask yourself those questions. If you're doing that, ask yourself, okay, is it for some kind of an educational purpose? Is it nonprofit? Is what I'm doing somehow transformative of the work? In other words, if I am providing this work and then using it for the purpose of parody, for example, or some kind of criticism, like a work of from a book, literature, and I'm explaining to the student body the criticism that I would have of the way this was expressed. Those are things that are going to determine whether there's going to be a fair use defense available. And an alarm bell should go off anytime you copy.
Yeah.
And then you need to ask the questions: what am I copying? Is it in the public domain? If it's not, okay, how am I going to use it? What effect it's going to have on the owner of the copyright in that particular work? Is the purpose commercial, non-commercial? Is the purpose educational? Is the purpose scholarship? You need to ask yourself these questions and determine, weigh that and see, okay, can I do this? Do I need to ask for permission from the copyright owner? And sometimes I'll admit, it can be difficult to find the copyright owner and get
Sure.
that permission. So that's not always easy. And, and then if the answer to those questions are, I'm not sure, then you have to ask yourself, well, am I willing to risk it?
Right. Do the right thing. Jim, you have brought so much expertise and experience to the table today. This has been fantastic, and you've given us so much to think about. As we said in the beginning and throughout, it is getting easier and easier to just push past and avoid copyright laws every day with technology and so many other things going on. It's just so easy to get at things and, make them your own without even thinking about it much. But this is an area we have to be knowledgeable in and we have to be alert about, regardless of who knows or who might find out. We need to do what is right and what's pleasing to God. So, Jim, thank you so much for taking time to clarify and shed light on just so many different items today. This has been incredibly helpful, and it's just been such an honor having you on the show.
Well, thank you, because, it's not often that people want to learn about this ton of things that I can talk about, so it's a pleasure to be here. Thank you very much for having me.
We greatly appreciate your time. And to those of you joining us, thank you for being with us today as well. I hope you're signing off today with a new level of awareness and really some good information to use in your classroom and to go share with others. Remember to go to teachereditionpodcast.com to learn more about the show and to submit questions for our upcoming episodes. Of course, be sure to subscribe to the podcast and go follow us on social media. Now it's time to get back to your day, but it's not just any day. Every day in the classroom is your day to impact and inspire through God's power and through His grace working in you. Go do what God has called you to do.